Good afternoon, everyone. Thank you for logging on today. Thank you for registering for this webinar. My name is Derek Bizzo. I am a staff attorney here at the National Congress of American Indians, and welcome to today's webinar, Tribal Water Codes, What Are They and Why Are They Important? Before we get started, I wanted to acknowledge some of the partners that were instrumental in getting this webinar started. So first, ourselves, we are hosting an organization as well, but we are working in conjunction with the Native American Rights Fund, the Tribal Water Working Group, and the Utton Center out of the University of New Mexico. Now, a lot of this work is people that are very passionate about tribal water rights, people who have worked on tribal water rights in the past, and they felt like the need was, the time was now for folks to come together and start discussing how do you quantify tribal water rights. This is the first webinar in a series of what we hope will be several webinars. We'll be looking to the feedback from this webinar from all of the attendees, yourselves, and hopefully that'll guide us into what type of issues and areas that you guys would like us to present on in the future. Moving on, we have some speakers here today that we're very pleased to have. Mr. Wes Martell unfortunately could not be here, as well as Mr. Joe Garcia. He's running a little bit late. Joe Garcia will be moderating today's session, and Wes Martell is the co-chairman of the Eastern Shoshone Tribe. Unfortunately, Wes Martell is dealing with a funeral situation on his reservation and was unable to attend. But we also have with us here today, we have Miss Elise Teton. Elise is an enrolled member of the Shoshone-Bannock tribes and has worked in the position of Tribal Water Engineer for the Tribal Water Resources Department for the past 14 years. In her position as the Tribal Water Resources Water Engineer, Ms. Teton administers and enforces regulations for the development, preservation, and protection of water resources on the Fort Hall Reservation, pursuant to the tribe's 1990 Fort Hall Indian Water Agreement and subsequent water quality ordinances. Welcome, Elise. We also have Mr. Peter Caposella, who represents Indian tribes on a wide variety of legal issues. His practice focuses on natural resources, jurisdiction and sovereignty, and compliance with the Single Audit Act and OMB circulars. He is engaged in complex federal litigation on environmental law and the protection of cultural resources and legislative advocacy in Congress on land and water claims. We also have sitting in today to assist us since the absence of Mr. Martell, Mr. David Gover, who is a staff attorney with the Native American Rights Fund, and myself, a staff attorney with the National Congress of American Indians. Now, a couple of housekeeping items. We will have a question and answer session, but we'll wait until after the presentation. We hope to get through our presentation and open it up for question and answers. And there are two ways you can ask a question when that time comes. One, you can raise your hand. There's an icon on your screen right now with the ability to raise your hand, and I can call on you. Or two, you can type it into the question box, and we'll place them in a queue and answer them as we receive them. Okay? So moving on, we'll move to the next slide. And at this point, I'd like to pass it over to Ms. Teton to give us an initial briefing.
Thank you, Derek. Good afternoon, everyone. Like Derek said, my name is Elise Teton, and I'm the Tribal Water Engineer for the Shoshone-Bannock Tribe's Water Resources Department. The tribes themselves settled their on-reservation water rights, which mandated the actual water code. I was hired on as a result of that 1990 Indian Water Rights Settlement, and my position can be considered implementation of the settlement or agreement, including the development of the water code and finally implementing it. I suggested this slide. I thought it was important due to my inexperience in law in general when I was initially hired and the general understanding of what a code was. Now that I've worked for the tribal government for a little over 14 years now, I have a better understanding of tribal law, and particular water law and its technicalities. So those of you that are well versed in law, please bear with me as I discuss this slide. So the term code is generally known as a body of regulations or a system of regulations to govern the conduct of people of a community, society, or nation. In this case, tribal nations or tribal governments. In my case, the Shoshone-Bannock tribes. Codes help tribal governments regulate their resources, activities, or conduct within its jurisdiction. Examples of codes include law enforcement codes, business codes, health codes, tax codes, etc. These codes fulfill the public interest goals and needs. For our discussion today, we'll be focusing on tribal water codes. Specifically, codes help tribal governments regulate the use of water and activities that impact water resources so that we may protect or preserve their interests. I'm now going to turn it over to Peter Capsola to talk about the importance of water codes.
Real, Peter, before you start, I'd also like to introduce Joe Garcia. He just joined us. Mr. Garcia is the first Vice President for the Southwest region at the National Congress of American Indians. For those of you that don't know, Mr. Garcia is very active and supportive on a variety of issues, including tribal telecom, tribal tax policy, tribal water rights, and Indian education and healthcare, just to name a few. Mr. Garcia is a proud citizen of OK Wingay Pueblo, located just north of Santa Fe, New Mexico. Welcome, Joe.
Yeah, Derek, I was trying to speak and try to get everybody online, and I could hear you all fine, but I could not get online. I hope you can hear me at this time.
Yes, I saw that was a situation, and I unmuted it, so you're live and on the air, sir.
Okay, thank you much, and I guess I will do my welcome, and I appreciate you filling in for me, Derek. I want to welcome all of the attendees to the webinar. This is the first, as Derek had said, but I think there'll be others to follow, and how well this session goes will be an indicator for how we need to improve for the next go-round. But thank you all for being online, and I just wanted to make a statement about water rights. And the Indian country of the United States of America has been in water litigation for as long as I can remember, and it looks like we will continue. But one of the prime things that we need to worry about is the water rights of sovereign nations, as sovereign powers, as sovereign entities. But as you all know, the federal litigation and other things has sort of limited our sovereignty, if you will, and we want to get beyond that. But we can't just give up. We just got to keep fighting, and the more we stay united on these kinds of efforts, the better our chances are that we'll be successful. So thank you all for being online, and thank you to all of the presenters. And Derek has already introduced you all, so I don't need to do that, but I think we're up to number 5, slide number 5.
Yes, sir, and Peter, go ahead and take it away at your leisure, sir.
Thank you. This is Peter Capsola. I'm a lawyer. I work with tribes on natural resources issues primarily. And in my work, I have worked closely with water engineers, such as Ms. Teton at Fort Hall, and the directors of tribal natural resources departments and EPA programs on issues including issues relating to the development and implementation of water codes. And as has been alluded to, water is an important treaty right, and it's important to the quality of life throughout Indian country. And you know, the regulation of water is directly related to tribal sovereignty. And so the different areas of life for Indian people, in large part, revolve around water. So this is really important work, I think. In my work as a lawyer with tribes on water codes, I work in 3 areas: drafting and developing codes, working with communities and staff and tribal council, and putting codes together and drafting them and enacting tribal laws, and then also implementing those codes in the process and procedures of issuing water use permits to water users within reservation boundaries. And that process seems to inevitably invoke jurisdictional, potential jurisdictional issues on those reservations that have been allotted and checkerboarded. We have non-Indian homesteads interspersed with family-owned allotments and tract of tribal land and using water on a reservation. And that's what the Colville versus Walton case was about. Was the jurisdiction of the Colville Confederated Tribes to apply their tribal water code to non-Indian water use on fee land within the reservation. Now, the general test that the courts have developed, they call it the Montana test or the Brendale test, to determine if tribes exercise civil regulatory jurisdiction over non-Indian activities on fee lands within reservation boundaries. The so-called Montana test is whether the non-Indian activity affects the political integrity of the or economic security of the tribe, or the health and welfare of tribal members, or there's a consensual agreement with the tribe for regulation. And so they look at the impact if there's no lease or contract with the tribe, as is often the case on deeded lands within the reservation. They look at the impact on the tribe and the tribal membership by this non-Indian activity. So in the case of water codes, there was a dispute where a non-Indian water user on fee land upstream from tribal fishery could take water out of the no-name creek on the reservation with a permit from the state, a water use permit from the state, but not in compliance with the Caldwell Confederated Tribes Water Code. In determining whether or not that water code could be applied to the tribe, the Ninth Circuit Court of Appeals determined that the regulation of water on a reservation is critical to the lifestyle of its residents and the development of its resources. Especially in arid and semi-arid regions of the West, water is the lifeblood of the community. Its regulation is an important sovereign power. And so in that case, the court found that a non-Indian taking water out of a watershed wholly within reservation boundaries, even though it was on deeded land, was subject to the tribal water code, and that water user needed a water permit from the tribe, not the state, in order to continue his water use. And so under certain circumstances, because water is such an important aspect to life in Indian country, under certain circumstances, tribal water laws do get applied to non-Indian water users on fee land. Now, not under all circumstances. And it depends on the impact and it depends on the watershed. But it's an important attribute of tribal sovereignty which can apply to non-Indians in checkerboarded reservations on deeded lands. So it's important to the quality of life, and it's important for its regulation is important for tribal sovereignty, and the courts have agreed with that. And maybe that's a good segue into the next slide.
Yeah, thank you, Peter. We appreciate those words. As noted, from a tribal perspective, it's important to note that water is a precious resource, and it's important that we understand the need for Indian tribes to regulate their water resources. Yes, as Peter noted, and as on this slide, this is definitely a sovereignty issue, and it's a self-governance issue, and in some instances, it's a treaty rights issue, and I think everybody understands that. But it's also a public safety issue, a potential economic development issue in some instances, and a health and well-being issue as well. And I apologize that Wes Martell is unable to join us today because he's one of the most adamant tribal leaders I've met as far as believing wholeheartedly that tribes need to define their own terms by which water is used on their reservation. And this kind of gets us to that last issue right there on your screen, the jurisdictional implications. It says federal government, state and local governments. But right now, the federal governments have original jurisdiction over tribal water rights. But due to an amendment made in the 1950s, states can also adjudicate tribal water rights, although they must use federal law when determining the Indian tribe's right to water. This creates a hazy situation when we talk about issues like venue and the resultant process of that venue. But it's Wes's view, and since he's not here, I want to relay his thoughts that I know he would love to make clear, that Indian tribes need to establish water codes so that they can negotiate or even litigate from a position of legal and government standing, rather than using a state's definition of water usage, for instance. And I know we have some practical issues as far as the 1975 Department of Interior moratorium on approval of water codes, but you know, I guess that only applies to tribes that the Constitution requires to seek approval by the Secretary of Interior for their codes. But yeah, as we move forward, the panelists will get more into the nuts and bolts of water codes. But I wanted to share that brief overview, and I may chime in from time to time just to if I have something to add. But I also wanted to ask Dave Gover, an attorney at the Native American Rights Fund, if you wanted to say a little bit more about either the jurisdictional issue or the moratorium issue.
Well, yeah, this is David. It's a pleasure to be on the line. I appreciate all that are here. The 1975 moratorium, you don't want to spend a lot of time on it, but it is born out of the jurisdictional concerns of whether tribes have the authority to regulate non-member or non-Indian folks within their boundaries, as Peter described earlier. But that's for tribes that were part of the Indian Reorganization Act of 1934. So if you have a constitution that was born out of that act, then there may be a moratorium that makes it more difficult for the tribe to implement a code. There are some exemptions. You can ask for some exemptions for the interior, or it may be resolved through a water rights settlement as part of that settlement. So those are things to keep an eye out, and we'd be remiss if we didn't mention that. So folks with IRA constitutions should be cognizant of that moratorium.
Thank you, Dave. Mr. Garcia, did you have anything to add?
We're still on slide number 6. I think the important thing to realize is one of the things that many tribes are trying to do or want to do, I think, is the quantification of their water, and in some cases could be advantageous. In some cases it could be a disadvantage for the tribe, because if you quantify, then it may limit to past usage versus the future usage. And I think it's important that in the document, the water code that you develop, that quantification piece needs to be really, really closely looked at before you start drafting what might be past usage, time immemorial usage versus current usage versus future usage, because we may then limit our own usage amount, if you will. But just an important piece that sometimes we don't talk about it or think about that too much. So I just wanted to add that as part of our discussion. Go ahead.
I think that's a good lead into the next slide, Mr. Vice President. You know, the water, there are different tribes all over the United States with many different cultures. They have different treaties, and there are different situations, different land bases, different threats to their water resources and to their environment. And having said that, there's tribes face many common challenges also. And I think part of the objective in this afternoon's webinar is to highlight some of the commonalities and the common issues and challenges facing tribal water administrators, and also to note some of the different issues and the different approaches or different options that tribes might have in addressing those challenges. Most tribes, of course, in the western states, in addressing their water rights issues, deal with states that have prior appropriation systems and state water engineers. In the eastern United States, water law is largely governed under the riparian system, where properties adjacent to water flows have the automatic right to reasonable uses of water. Tribes might have different approaches or different needs when it comes to consumptive uses. Some tribes may have predominantly dry land farms. Some tribes may need irrigation in order to undertake any agricultural pursuits. Many tribes out here, well, I'm located in the Pacific Northwest, their treaties guarantee fishing rights. And those fishing rights are central to the way of life for the Northwest tribes. And so there are many differences and different needs, but when we look at water codes and the administration of water in Indian country, we find a lot of commonalities also. Water quality is a real important facet the administration and regulation of water generally. And many tribes work, have grants with the EPA, of course, for 106 programs and for the development of water quality standards. And water rights does include water of a sufficient quality for the water uses. But when we're talking water codes, by and large, we're talking about water use codes and the implementation of permit programs for water use in Indian country. And so the codes that, the water codes that we're talking about today may very well have water quality components to it. And that's a choice that a tribe can face. That's an option that a tribe could do, is develop a regulatory agency that regulates the diversion of water out of a stream or river or a lake or groundwater, the pumping of water and the diversion and beneficial use of water, and the protection of water quality. The funding agency for the water quality piece is the EPA, but some tribes have separate EPA programs aside from their water resources program or natural resources program. So there's different ways to do it, and different tribes set their own priorities as part of tribal sovereignty. But these are just some of the common areas that are in water codes. We're trying to highlight the themes that are challenges to everybody, but also to respect the differences and the different needs that different tribes have, and then how that gets incorporated into the code. So we're going to review some of the common provisions and language, just taken out of some tribal water codes for different tribes in the West. I have worked for many years for the Standing Rock Sioux tribe, which has had a water code since the late 1970s. And the tribal water code highlights, and I think the Declaration of Purposes in the first section of the code really give an indication of the tribe's worldview when it comes to water. That the purposes of the code are promote the general welfare of the tribe and develop, manage, protect and protect and preserve the waters of the reservation for present and future generations, exercise sovereignty and tribal sovereignty, and also ensure due process for water users on the reservation. And I think that's an important piece right there. And it's something that, in my role as a lawyer, is a big part of what I do in working with the Tribal Water Resources Control Board, is to ensure that water users on the reservation that are seeking a water use permit from the Tribal Water Board enjoy their due process. And often, in jurisdictional issues pop up, and if tribes assert jurisdiction over non-Indians, they complain that the tribe should not have jurisdiction over their water use, even though they're using reservation waters. They complain that somehow tribal administrative systems don't treat them fairly because they're not members of the tribe. And so water codes can set out the procedures that the administrative agency, the water board, will follow, and that the courts will follow. And one of the very purposes of tribal law is to make sure that anybody who seeks to use water in Indian country, whether or not they receive a water permit or not, but that they're all treated fairly. And that bolsters the tribe's jurisdiction and sovereignty.
Elise, did you want to add something to slide number 8?
Sure. I think one of the items that is unique to the Shoshone-Bannock Tribal Water Resources Code is that we have a special section because our water code has to be approved by the United States. There was language that was necessary to be added for us to get it approved by the Secretary of Interior, and that was for allotee water rights. The language that refers to any allotment that was for ag purposes under the General Allotment Act 25 U.S.C. Section 381, which secures water for allottees, is entitled to request and provide an equitable distribution of a portion of the tribal water rights. Our department and the commission are to ensure that these allottee water rights are secured per this Section 381. But this Section 381, however, does not apply to allotments established for grazing purposes on the reservation. So that was something more unique to our code, and this is something possibly for some of those other IRA tribes that you may have to consider when working on your water code.
Thank you. Peter, we're into common provisions, statement of ownership. Go ahead and move forward.
Yeah, thank you, sir. You bet. One other point to follow up on Elise's explanation of her work to ensure that the allottees on her reservation enjoy their proportionate share of the tribe's water right, is that, and we've talked a little bit about quantification and how that fits in. And, you know, largely we're talking about the administration of waters that have been subject to a quantification, either an adjudication or a compact with the state. But also, even if a tribe does not have an adjudicated water right or a water right under a perfected under a compact, the tribe still possesses vested property rights in the water on the reservation. They just haven't been enumerated yet. And so a water code can be developed and implemented even if there has been no quantification of those waters. Having said that, like in Elise's situation at Fort Hall, her office regulates, as she explained, the water under the compact, including to the allottees, and that's an important part of it. Now, when there is legislation in Congress to approve of a tribal and state water compact, and when a tribe's water rights are quantified in that way, the legislation through Congress will provide for the tribal water code, as Elise had explained, for the Shoshone-Bannock tribes. And that legislation will identify the water code as the tool to regulate the implementation of the tribe's water right, approved by Congress as part of a settlement with the state in a compact. So there, the Secretary would have limited, even with the moratorium, the Secretary would have limited authority to disapprove of a tribal water code. And so the moratorium may not even apply to tribes who have federal legislation to quantify their water rights. Now, as I said, regardless of the quantification, tribes have treaty rights to water. And that's what the Winters Doctrine says, is that the treaties or other agreements between tribes and the United States implicitly reserves all of the water reasonably necessary for the land identified in the treaty to be a permanent homeland. And so it's a treaty right. And in the Navajo Nation Water Code, the nation defines its view of its treaty rights to water. And these are the waters that are then going to be subject to regulation under the code. So it's common in a tribal water code to set out the tribe's definition of its water rights, as the Navajo Nation has done in its code. And the nation determines the owner of the full equitable title to all of the waters of the nation. Now, title resides undiminished in the nation and goes on to identify the strictly what the United States is interested in. And that's their legal title exists solely as trustee. And the Navajo Nation sets out very clearly that it is the property owner of the waters of its reservation, not the United States. And that all use of those waters are subject to the consent of the nation. And so asserting ownership of the water, identifying the water subject to the water code, that's a treaty right. And then exercising sovereignty over that water And this is language that's found in the Navajo Nation Code, and it's very strong language asserting a property right to the water. And, you know, it's easy. We can draw a map that shows your reservation of land identified in a treaty or perhaps an executive order. Winters Doctrine rights are implied rights. And so sometimes it is not as easy to conceptualize the existence of those rights. And so it's important in a code to set that out in strong, clear language. And the Navajo Nation Code contains very strong, clear language asserting ownership of the nation's water rights. And I think this is a really good example of language which does just that.
Leading on would be also that depending on the tribe and the region from where they reside and the conditions that they have, also it's important to find the commonalities of the code, but specific issues may be different from one nation to another, as you'll see Peter described the waters of the Standing Rock Reservation. Peter?
Yeah, thank you, Mr. Vice President. And this is just an alternative way of defining the waters of the reservation. And, you know, it's more of a scientific or technical approach, talking about waters located upon or bordering, whether above or below, whether diffuse or contained in a defined water course. All waters reserved at any time by the Standing Rock Sioux tribe or by the United States for their tribe. Natural, which flows or stanzas exist of nature or artificial works, or flows into or out of it. So just another example of a very broad definition. And these broad definitions often get quantified through water compacts or adjudications, and then a tribe will have a set amount in that federal legislation, perhaps, or a court decree, which identifies exactly what waters are going to be regulated under the tribe's water code. Now, the most common method that tribes regulate waters, whether they're defining a quantification or unquantified and flowing through or bordering the reservation or groundwater on the reservation, is through a permit process. And a lot of what Elise does as a tribal water engineer at Fort Hall is oversee the implementation of a permit program for tribal waters, defined broadly based on the treaty, like with the Navajo Nation Water Code, or defined by looking at the geography of the reservation as Standing Rock did it. But Elise, maybe you can talk a little bit about the implementation of the permit program in your office, and I think that'll lead us into the next slide.
Sure. As Peter mentioned, in our settlement, we were allocated a set amount. However, in our water code, the definitions do explain and outline it's all reservations arising on, under, or bordering the reservation, that we were allocated 580,031 acre-feet in the name of the Shoshone-Bannock Tribe Sports tribal members and the allottees. We were given a number of sources on and off the reservation out of the federal reservoir projects, groundwater natural flow, and many streams on the reservation. So we have numerous supplies. And of course, you know, once you're allocated and you settle these amounts, you've got to set a system, an orderly system, which is pretty much an inventory to track and make sure, you know, who's using water and staying in compliance, and that's by the development of the permit system itself.
And we took just some provisions out of the Yakima Nation Water Code, and the Yakima tribe, as Derek mentioned this morning, some tribes under the McCown Amendment can get pulled into state court and have their water rights adjudicated in the state court, that prompts many tribes to try to settle through negotiations because of all the problems associated with the state system. But in administering their water, there's a water permit program set out that's probably similar to very many tribal water codes in the West, where any water use of the tribal water resources, which we saw the definitions of tribal water resources at Navajo and Standing Rock, but water uses require tribal water permits, which is the tribal nation's approval to water use, temporary. It can be revoked or renewal can be refused for failure to comply with the provisions in the water code. And so the Yakama Nation system that's set out is probably very similar to water codes in many places in Indian country. Elise, would you explain how you do what your permit process is at Fort Hall?
Sure. You know, our permit system, you know, I'm looking at the Yakama Nation, you know, that last bullet. Our code also does not allow a property owner to create a property right. They just have a right to the water use for a permit that is under the ownership of the Shoshone-Bannock tribes. So they may have the ability to apply for a water use, but they can never sell the water rights. However, we want to make sure that they enjoy the benefits of having some of the tribe's water rights, but because we have it in our name, we want to keep it intact and the water right whole, and by putting it in the tribe's name helps us not ever diminish our rights ever. So our permitting system, you know, we have a number of types of beneficial uses. We have permits that are for tribal members. We have permits that are for tribal entities, and we have a permit for entities that are leasing tribal member lands or allottee lands. And then we permit each one of those. We also have a licensing system that allows for any work inside the reservation waters. So we have a stream zone alteration license, which is similar to a 404 permit with the Corps. We have a discharge license, which is similar to the MPDES permit that the EPA puts on. We also have a well construction license for drilling of wells. So we have the system put in place, and the code allows us to set up the process, filing an application, having the technical staff go out and do all the research and investigation, and then making a final recommendation to the commission for denying or approving or conditioning the permit or license.
Mr. Vice President, this is David Gover. I'd like to make one observation. When a tribe is considering defining the waters of the nation, they're not always necessarily bound by the land reservation. You'll see a lot in the Northwest that those can also exceed off-reservation depending on the hunting and fishing rights that the tribe might possess as well, and the implied water right that extends to support those treaty resources. As we all know, sometimes the land boundaries aren't abided by a fish that travels off and on reservation. So those are important factors to keep in mind for tribes that might be similarly situated to exercise authority over water rights that are off reservation.
Thank you, David. Just as any code, if you think about an example, law and order code, how effective those codes are really dependent on the implementation part of it, and a lot of it has to do with how the codes are implemented, if you will, and how the enforcement takes place. So, Elise, you're designated to talk a little bit about the administration of a code?
Sure. Sure. So a majority of water codes are established to pretty much set up the infrastructure of the department or the program that's to carry out the regulation and purposes of the water code. Each code's different, and final decisions or permits or licenses can be made by a board or a commission, and in some cases by the department head or engineer. In our case here on the reservation, I'm not allowed to make decisions on permits or licenses, that authority lies with our commission. We simply do the research, the legwork, the technical work, and we make a final recommendation to our commission on all the permits and licenses. The code set out an orderly system of an inventory by means of a permitting and licensing system that I had mentioned before. So subsequently producing a product of an inventory for the purposes of the code. Once your inventory is complete, meaning your permits and your licenses, you need to ensure you have consistent management in times of need, such as drought. This allows you to see that and have an inventory of all your permits and licenses, and then further enforcing of those permits and licenses to ensure that everything's in compliance. Of course, when developing and implementing water codes, there's always costs associated with that for the implementation, the administration, and enforcement. So it's necessary to have funding available to do so. So in some cases, you know, it's very important that you set aside the monetary resources to have this program there to, whether it be before, you know, or after your settlement. In our case, our settlement set out funds for us. However, it wasn't enough, so we've had to be a little bit more creative in how to bring funds back into the department. But our settlement actually allows for water marketing, which has really allowed us to expand our department and pretty much fund our department by allowing the water marketing.
Thank you. The next piece is has to do with the delegation of authority, and question might be, you might want to think of it while we're in discussion over this, is the authority delegated to waters that flow off the reservation, or waters that come into the reservation, and how those might be affected by the water code. Elise?
Sure. So, you know, of course, because our governing body, you know, of the tribe, which is, you know, in our case is the Fort Hall Business Council, they can't be experts in everything. And but we also have to allow for the separation of powers when we are developing our regulations and implementation. Our Constitution and bylaws of the Shoshone-Bannock tribes allow for the Fort Hall Business Council to delegate their authority to a board or commission. In this case, they developed the Water Resources Commission to enforce and oversee our water code. And our council made it very clear that they wanted no involvement in the appeals process and directed that it go straight to tribal court. So they set up the system so that this whole department can manage and administer the system for all of the water rights that we were given and on reservation. Even if we don't have a portion of it, we still have authority to regulate and monitor what's going on our reservation water resources. Next.
All right, next slide, number 13, I believe. Or is that it? 14. Should be 14. Elise, you continue, and any David or Derek or anyone else that may want to also add something, we'd appreciate it. Go ahead.
Sure. So as I mentioned in the previous slides, codes usually define the infrastructure of the management system establishing the commissioner board. So it's necessary in the codes to detail the duties and responsibilities of the commission and or the water engineer. And right here on this slide, it actually itemizes some of the duties and responsibilities of our commission, essentially supervising the execution and enforcement of the code's provisions and regulations, approve or deny water use permits, conduct hearings and render decisions regarding water permit applications, and to hear any disputes regarding the water management decisions of the tribal water engineer, and of course to adopt the rules, regs, and permit forms to carry out the purposes of this water code. We could go to the next slide. So as I mentioned before, In this particular case, in the Navajo Nation, the director of the Natural Resources Division can make the final approvals and grant, deny, modify, or revoke water use permits. They can make a determination of water use rights, initiate proceedings to enforce the code, ensure adequate levels in the streams, rivers, ponds, and lakes to protect Navajo traditional religious practices, wildlife conservation, and other values. And that's in the case of the Navajo Code. But here on our reservation, as I had mentioned, I am not allowed to do that. I can't approve or deny any permit or license in the code. That is delegated authority to our Water Resources Commission.
And this slide here would give a comparison of what other tribes are, how they are operating under a similar system.
Yeah, I think there's two main functions that we find in water resources management. The technical function, as Elise described it, going out in the field and measuring and monitoring stream flows, and determining water use out of a ditch, perhaps, or looking at groundwater in wells and monitoring groundwater pumping by a particular water user. The field work, taking inventories of the resource and inventories of permits and water uses authorized by the tribe and perhaps even by the state off reservation. And then there's the administrative task of issuing permits, of revoking permits, or even of adjudicating disputes of priority, perhaps during drought or periods of shortage. And often in tribal water codes, we find boards that do the administrative functions, and the Tribal Water Resources Department and the Tribal Water Engineer doing the field work and providing good, sound, scientific, technical data to the board so the board can make good decisions when it issues permits or adjudicates disputes among water users in an administrative hearing. And that implicates, as Elise said, separation of powers. Not to do it at the council level. That's a legislature. That's a legislative body that makes laws for the entire nation. Not to resolve disputes. That's an executive task under a separation of powers, where you have an executive branch of the tribal government implementing tribal law, including a water code. But often the board, regardless of who has the authority to implement the permit program, whether it's a board or whether it's an official, such as at Navajo, where the director of the Natural Resources Department is authorized to do that, during periods of shortage especially, and many areas in the West are facing severe drought right now, and severe shortage right now, and this may even get worse in the future, perhaps even the near future, because of climate change and long-term diminishment of water resources and prairie streams in the West, where water systems might have more permitted water uses. A water board might have issued more permits than there is water in a particular watershed during a drought. Well, then there's a dispute between water users, and they could be tribal members or they could be non-Indians on fee lands, but with different permits, both wanting to use waters that may not be flowing during a period of shortage. And so most water codes set out the standards for resolving those kinds of conflicts. And the Standing Rock Sioux Tribe Water Code requires the water board to afford preference in resolving the disputes based on two things. One factor is seniority, the earlier water permit, but that's not the determinative factor. The other factor is what's the use. And the water code prioritizes water uses for the reservation, with domestic and municipal being the highest uses, agriculture and livestock also being identified uses, and fish and wildlife. And so depending on the water use and the date of a water permit, if there's not enough water in the system, the Water Resources Control Board on the Standing Rock Sioux tribal government will make a determination of who will get to use water out of that watershed that given year. Now the seniority reflects prior appropriation doctrine of water law. But unlike many state laws, the Standing Rock Water Code does not rely exclusively on seniority and looks at what the use is too. Now, as Derek had said earlier, here in the Northwest, where fishing is an important way of life and treaty right, in-stream flows for fish and wildlife under a tribal water code may get a different ranking of priority, but that's different tribal nations obviously have different needs. But that's how Standing Rock does it. And it's one of the things I think that are going to happen more and more as tribes implement their water codes is tribal water agencies resolving administratively disputes between water users in particular watersheds during periods of shortage. And this is how a tribe that I work for addresses those kinds of conflicts, which hopefully won't come up. But we are in drought conditions, and no question about it, climate change jeopardizes our water resources in the long term. And so that makes the implementation of the water codes and resolution of disputes that much more important attribute of tribal sovereignty act.
Well, that's the important piece. The other important piece is that when the code is in place and permitting is allowed, there's got to be language available so that it doesn't lead to litigation. I think you kind of alluded to that. Instead of it going to litigation, there ought to be ways to, in cases of severe drought and other conditions, that the permits can be retracted in a more of a systematic way than wait and say, well, geez, there's no water, so you can't use it. Better to have looked at the situations, sort of if analysis, if you will, and kind of talk about that and put them in within the codes, of course within reason, but to look at those kinds of severe conditions would be a plus, I believe, rather than to wait till it happens. And so if those aren't already in the codes or developing the codes, people might want to consider that those might be viable alternatives in the language.
You bet. And also, as a matter of sovereignty, it's helpful when the tribal government is able to have amicable dialogue with the states. Some states are more amenable to that than others. And that dialogue, that intergovernmental dialogue between the tribe and the state can go a long way for good natural resources management all the way around.
Right. And that kind of leads into the next slide about due process. We're talking about preliminary at the onset of permitting and other things, as well as the after permits have been issued and the language has been or the codes have been developed. You want to be sure that we don't overstep the due process. So you talk about that a little bit, Peter.
Thank you, Mr. Vice President. And I alluded to it earlier. When Indian nations exercise civil regulatory jurisdiction over non-Indians, a common complaint, they try to avoid tribal jurisdiction, even though they're in Indian country doing activities that are regulated by the tribe. And it's a common contention that they're not treated fairly by a tribal water board, perhaps, or a tribal court. And so to set out in tribal law that full due process rights in the issuance of permits, in resolving disputes that may arise among different water users, and at every step in the process of water resource management, it undercuts the argument that non-Indians have made that they're not treated fairly by tribal regulators and should not be subject to tribal law or tribal regulations. And the Yakima Nation Water Code addresses it very neatly and just incorporates by reference the Indian Civil Rights Act as applying to all actions taken under the Water Code. Some tribes in their water codes will set out the detailed procedures ad infinitum. You get your tribal attorneys involved, but this is a real nice language in the Yakima Nation Code, which says it in black and white that the full protections of the Indian Civil Rights Act apply to every action by their water board and tribal water administrator. And that's really important to bolster tribal jurisdiction. And David and Derek both had just talked about tribal sovereignty as being so central to this. And this backs up and this buttresses tribal sovereignty by making sure that in a tribal system, all water users are treated fairly at every step. And I don't know if Dave or Derek might have anything to add as tribes implement these codes and exercise sovereignty in this way, even over non-Indians.
This is David. I think what this shows is that it gives people a level of, or it gives states and non-member or non-Indian folks a level of comfort and familiarity that their due process will be protected within the tribal system.
You bet, which is not to say that it's easy, because of what Vice President Garcia said. The specter of a legal dispute will hang over the tribal water engineer whenever he or she is asserting jurisdiction over non-Indians. And so it's important to protect the sovereignty of the tribe and not compromise the sovereignty of the tribe, but at the same time to not get caught in a jurisdictional dispute which might result in a situation of one step forward and two steps back, because the courts are not favorable to the tribes generally at this point in our history. The advice that I try to give to tribal regulators is follow the code strictly. And if you follow your code strictly, no matter how where the chips fall, that's your best strategy to prevail if there's a jurisdictional dispute or legal dispute later on. So follow the code and the procedures of the code as strictly as you can, including due process for all water users subject to the code.
Yes, and a common point, I guess, might be a question more, might come up later, but it has to do with courts of jurisdiction. So either we can talk about it now, or maybe in the question and answer piece that might be an issue. So are we at 18, 17? Alicia, would you want to talk about that a bit?
Actually, Peter's going to talk about...
We're on the field. Go ahead.
I think jurisdiction is something that many tribal water managers have to deal with, and it's a real common concern. We talked earlier a little bit about the Colville versus Walton case, and in that case, the court set out a rule that tribal water codes will apply to non-Indians on fee lands within watersheds that are wholly within reservation boundaries. And so your border waters are going to be more difficult to apply your water codes to non-Indians than watersheds within the reservation. And that's something for water managers to look at in terms of trying to figure out who needs a tribal water permit under your code. So the courts look at it that way. Does the watershed flow through the reservation and is part of the watershed outside of the reservation, or is it wholly within reservation boundaries? And how pervasive is a groundwater source? Is it a very large aquifer like the Oglala Aquifer in the Central Plains, or is it a shallow, localized aquifer where pumping is going to, pumping the groundwater will directly affect neighboring wells? So those are the things that the courts look at. As Vice President Garcia mentioned earlier, working out agreements to avoid litigation is always the best way to go, if it's possible. It's not possible with all states because different states have different approaches and different levels of cooperation with the tribes too. But if a tribe can work out an intergovernmental agreement on tribal and state water codes as they apply to reservations that are checkerboarded, that's one way to resolve disputes under water codes and resolve jurisdictional issues under water codes without getting pulled into court. When there's a dispute amongst water users under the tribal water code, frequently your tribal water commission or water board is authorized under the code to hold an administrative hearing. If there's a drought and we have different water users on a creek on a reservation, there's not enough water flowing to fulfill both of their uses, but they both have water permits, and there's a potential conflict. And usually a tribal water resources board will have the authority to hold a hearing and resolve those conflicts. Now, if somebody is dissatisfied with the decision of that board, it's important that they have the right to an appeal. That's part of due process and civil rights. And so the way the Shoshone-Bannock Tribal Water Code deals with this very issue is it empowers the Fort Hall Shoshone-Bannock Appellate Court to hear appeals from decisions of the Commission. And those appeals are limited to the record of the Commission. So if there are differing water users that have a conflict, which generally happens during a drought or period of shortage, that's when there's not enough water to fulfill the different permits that might have been issued. When that happens, a tribal water board or water commission will generally be authorized under the water code to hold a hearing. The party that loses should have the right to appeal, and the best way I think to deal with it is just the way that the Shoshone-Bannocks have dealt with it, is to give a limited appeal right to a tribal appellate court, which does not hold a new hearing. That's what the water board is for. They're the agency of experts appointed by the tribe to filter through the paperwork and the data that the water engineer will provide as part of the field work that the water engineer's office or water administrator's office will be doing. Then the appeal court can address appeals simply on whether or not the law was properly followed, but they're not going to second-guess technical decisions made by the water board based on the data provided by the water engineer. So hopefully those are the steps in the process of resolving any disputes that might arise in the course of implementation of a water code. To the extent those disputes may involve a non-Indian on fee land, or if a non-Indian on fee land maybe will not acquiesce to a tribal water permit, then you have to look at the facts of the situation, work with the state and perhaps county, if it's possible, for intergovernmental agreement to stay out of court. But it could end up in a tribal appellate court. And all of these things that we're talking about get right back to issue Dave Goldberg talked about at the outset, which is tribal sovereignty. And so it's almost as if we've come full circle in the discussion.
Okay, that gets us to slide number 19, which is simply why is a water code important? And I think some examples are given in the slide that Eastern Shoshone, Shoshone-Bannock, Standing Rock Sioux, Navajo, and there are other tribes who have developed codes that in their litigation or mitigation, the codes have been advantageous to the nation themselves. But question will lead to some questions here, but I want to pose a question that might be a general big question, and that is that is it better to have codes in place before a tribe gets into litigation or mitigation, or do you restrict your water rights by having code and wait till after settlements have been placed and then develop water code? So might be a thing that we kind of look at as a comprehensive question, if you will. And so at this point, we're up to questions and answers. Unless anybody else wants to chime in on the why a water code is important. Peter, Derek, Richard, or David, Elise?
I would just like to highlight once more what Peter said earlier, is that it really, one of the big uses of a water code is it allows a tribe to prioritize its uses. By that, you're able to ensure that your community values are reflected in your water policy. And I think Peter mentioned several times the possibility of a shortage or a drought. And I think in those instances, when you have a shortage and a drought, if you have this code in place that's been prioritizing your water use, I think then is when you'll be most thankful that you had that water code in place. So that's the only thing I wanted to add on that note.
Right. Thank you. Anyone else?
This is Elise. I would like to add something, and it goes back to your question, Mr. Garcia, regarding when should you develop a code. I guess I would probably suggest that if you have the resources available to actually establish the water code and implement and hire the staff, I think it's in the best interest of the tribe before you even go into the negotiations or litigation. That staff, you know, they could be there measuring and collecting the data. It gives them a better understanding of how the system works and how much water is available going into the negotiations or the litigation. Your own staff know much more about the system and can help relay that to your maybe technical consultants and your attorneys as well. So I think that would be a benefit. And then secondly, I think the importance in what we've come to, and as I've realized, you know, working with the tribes, our tribal leaders have instilled in us and me that strengthening our tribal sovereignty is most important, and you do that by developing your own regulations and your own laws, and by doing it yourself here on the reservation to actually include, you know, your values, to protect your values. So not everybody looks at water and the use of water the same. You know, we look at it differently, so we can develop our priorities, you know, develop how we want to manage our water based upon our beliefs. And so with that said, you know, those are like cultural and traditional and spiritual type means that we can then prioritize because that's important to us. That's
right.
all.
All right, thank you. Anyone else?
Thank you. If I might, it's an important question if it's whether a water code should be entered, enacted and developed now, or if it's better to wait until after a water quantification. And I think Elise answered it very well. As the general matter, it's always better to put your code in place. Perhaps especially if you're going into a water adjudication or negotiation but haven't completed it yet, and to get that basis in tribal law. And one issue, though, when it comes to the enactment and implementation of the water code are the resources that are required. And the states really have a lot of resources for water resource management, and it's often a challenge for tribes. And so that's one caveat or one thing to look at in developing and enacting a code. As Vice President Garcia mentioned earlier, the code is only as good as the implementation of it, and the implementation of it requires financial resources. Now, we talked a little bit about the moratorium, the secretarial moratorium on the approval of codes. Even though the moratorium may not apply to a tribe that enacts and implements a water code, it reflects a broader federal policy not fully supporting the implementation of water codes. So when we go to the BIA for a 638 water resources contract for some money to implement the code, sometimes we get resistance. And I think we find across the board a need for additional federal support for Indian water rights and Indian water regulation and the protection of water in Indian country. And so hopefully the follow-up discussion to today's webinar will be a discussion on strategies to get the Department of the Interior, the Department of Justice, BIA, the Bureau of Reclamation, agencies like the Army Corps of Engineers, federal agencies that affect Indian water to be more supportive and provide more resources to tribes to protect your water. And so perhaps that's where we can go from here. In the meantime, getting that code in place and implementing the code and having the resources to fully protect your water resources might be one of the most important functions that Indian nations undertake.
Hey, thank you, Peter. This is Derek. We have some questions in the queue right now, so we're going to move on to some questions. But if we don't get to your question, please email myself at dbeetso@ncai.org, dbeetso@ncai.org, and I'll try my best to make sure your question gets answered. The first question we had is from William, and he was asking how can a Lati water rights be addressed in the tribal water code? Anybody want to take that question?
That might have arrived because of my statement in our water code, and that the United States actually mandated that this language be in there. For the ag purposes, our commission is not allowed to deny a permit to those 20-acre parcels, even if there is not enough water to go around. Each allotee will then share in a curtailment across the board, and that's how we would have to distribute it. So that would be my I hope it answers this question.
Derek, I don't have control over the queuing, so whoever's helping out there, I appreciate your help. I guess it'd be NCAI staff. This is Joe. So hopefully all the people get their questions asked.
Yes, I will make sure that happens. The second question we have is from Kimberly, and Peter kind of hit on it, and so did David earlier. But she wants to know why won't the Obama administration lift the moratorium, and have they been asked to do so?
This is David. We have the moratorium in 1975, and the initial thought would be there would be some rules that would help, and those were proposed in 1977 and failed, and then again in I think it was 1981 because of resistance from both tribal and non-tribal interests and the jurisdictional issues that are out there. I'm not aware that, I mean, I know it's always a topic for folks, but I don't know how hard Indian country as a whole has pushed for that removal of that moratorium. So that I think that might be a good topic for a follow-up webinar to better understand from the Department of Interior what their current position is, and if they are inclined to refine that position or not. But maybe that's better answered by Department of Interior or Solicitor's Office.
Agreed. The next question we have is from Jennifer, and she wants to know whether there are any common provisions in water codes that address something like a statement of ownership over water rights for off-reservation waters.
This is Peter. You know, we talked a little bit about different tribes having different situations, and there are tribes, particularly in the Pacific Northwest, but not exclusively in the Northwest, whose water rights involve in-stream flows. The amount of water that's in the watershed at different points in the watershed for water quality and for fisheries. And so some of those settlements would be the place to find that kind of language. It's related to fisheries, and so tribes whose treaties emphasize fisheries would probably be the tribes that would have those kinds of provisions in water codes if they have a water code. That's the context, I think, where it would most commonly arise.
Thank you. Thank you. Next, we have a request for the Shoshone-Bannock Code and permitting fees. I'll get your request. I'll get that with Elise Teton, and we can see if we can provide you that. We have another question from Kimberly that says, what are the alternatives available to tribes to punish or fine users who don't comply with the codes or refuse to submit to the tribe's jurisdiction permitting process? Are they limited by the Indian Civil Rights Act?
The courts have developed limits to tribal civil jurisdiction over non-Indians, kind of as a fictional outgrowth of the Allotment Act. And so for checkerboarded reservations, there really needs non-Indian water uses on fee lands in order to fall under the regulatory authority of the tribe are going to have to directly impact tribal water uses as a general proposition. If they do not, and they refuse to get a water permit, but they're using water on a reservation, it's going to be difficult to assert authority. But if there's water use on fee land within the reservation boundaries, and the water user might have a state permit, but will not acquiesce to tribal jurisdiction and will not get a tribal permit, if that watershed is a larger watershed that is off reservation and on reservation and then flows through, but most of the watershed is off the reservation, if that's the water source that the non-Indian is using, it's going to be very difficult for the tribal water commission or water board to require the water user to obtain a tribal water permit. If the water system is more localized, then the jurisdictional hook is much stronger. Now, usually water codes will have language, general authorization to the water board or the water engineer to take such actions as necessary to ensure compliance with the code. And that could include issuing an injunction or a stop use order, or issuing a directive to a water user to stop using water if they do not have a tribal water permit. But the jurisdictional issue is going to be there if the water source transcends the reservation boundary, even if it's an aquifer, if it's a larger, deeper aquifer. There has to be an impact on tribal water use generally to assert jurisdiction over non-Indian on fee land and their water use.
Thank you, Peter. We're getting a lot of questions. Folks out there want examples of tribal water codes and things of that nature. We can definitely see if we can dig up some and provide those. But also wanted to mention there's a Native American Water Rights Settlement database that the Utton Center is working on in partnership with other folks. And what that would do is it would create kind of kind of like a Google Map system or a mapping system where you could click on an Indian tribe and see what kind of water settlements they have. Right now, currently, I believe like 26 or 27 tribes have went through the settlement process, and so it's trying to get all the public documentation from those settlements available, as well as water codes for different tribes available, so that folks that have questions or concerns or want to know different approaches to either the settlement process or developing their codes will be able to access that database. It's in the works right now. It should be going live pretty soon, and we will keep you updated. And I just wanted to share that bit of information.
Yeah, and Derek, this is David. Again, we're looking forward to that resource from the Utton Center, but also National Indian Law Library does have some tribal codes, and within that there are some tribal water codes. Again, that's National Indian Law Library here at the Native American Rights Fund. So that's another resource that you might contact to see what our holdings are for tribal water codes.
Cool.
Are we close to the end, Derek?
Yes, we're close to the end. Perhaps we should move to some final comments, and then I'll sweep up the remaining questions, and then see if we can get those answered to you.
Okay. Closing statement. Who wants to go first? Peter?
Thank you, Mr. Vice President. You know, I want to thank the sponsors for asking me to participate. I've enjoyed it. Enjoyed working with you and setting it up. You know, in closing, you know, both tribal sovereignty and self-determination on water are not only Indian rights, but they're human rights, recognized by the UN and the Universal Declaration of Human Rights, and also in the Declaration of the Rights of Indigenous People. And so managing your water in Indian country is exercising treaty rights and your human rights. And it's an important task, and it's an honor to participate this afternoon. So thank you.
Thank you so much, Peter. Elise?
Sure, I'd like to thank the sponsors as well. I am too honored to participate in this webinar. I think it's extremely beneficial for the individuals that are on the line. I've been looking forward, after the water settlement was settled and approved, you then go into the implementation phase in the water code. Everything that I've been to has been about negotiations or litigation to get your water. Those weren't helping me as much, unfortunately. But this webinar, for those of you that are out there, hopefully will lead into some more implementation portions of the water code and regulations, and I believe through your questions and that you're going to be will lead us into the different topics of the different webinars that we may hold in the future. But again, I'm a resource if you all need to contact me. I believe, Derek, are you sending out our contact information? I'm not sure.
Yes, if that's agreeable to everybody, I would send out contact information. I would send out the PowerPoint slides from today. I will also send out a link to the webinar. We are recording it, so hopefully, the technological gods willing, we'll be able to post that online and have that available for folks to view too. So we'll be doing that.
Okay. Well, I'd like to thank everyone and thank everybody that's attending here today on this webinar, and I hope it's been useful to you. That's it.
All right. Thank you. Any closing, David?
I just want to also express my appreciation for the panelists to help assist with this webinar, and Derek, Beetzel, in the efforts, and Greg and Darcy, and Mr. Vice President, for your time. It's all a trial situation. I think we've had a good turnout. And I guess the one thing I'm always reminded when I'm traveling through Indian country is the understanding that water is life and life is water, and to keep that in our minds when we develop our codes and protect the tribe's resources. Thanks for allowing me this time.
Well, thank you for your time. Derek, anything closing before I close here?
You know, I think Dave summed it up. Everybody summed it up pretty nicely. I just want to thank everybody for participating. And we do have another webinar on Monday, and that's on tribal telecom, increasing access to commercial airways for tribal nations. There'll be a brief discussion about regulatory changes to provide negotiating powers for tribes to bring communication services to the reservation. I just wanted to note that. But again, thank you, everybody, and close us out, Joe.
Yeah, thank you so much, and I want to extend our condolences to Wes's tribe. I think they've gone through a lot of dilemmas with community members and whatnot, but our prayers are with them, and hopefully he knows that, and I think he knows that. But I want to thank NCAI, I want to thank NARF, I want to thank Tribal Water Working Group, and I want to thank Hutton Center for being the co-sponsors of this webinar, and to the individuals, Derek, and I think somebody working behind the scenes was Brian. He was hopefully the guy, or he was the guy controlling the PowerPoint and whatnot. And then thank you, Peter. Thank you, Elise. Thank you, David. And hopefully I saw at least 75 attendees on the list here. And so thank all of you for being a part of it. But just a thought is that these kinds of efforts can only happen if we take it on from a national level perspective, if you will. And the more power to us, and if we work it through NCAI to either discussions at the meetings and through talkings with the President of the United States of America, and working with our congressional people and sending a common message, I think will help us get there a lot faster than individually doing that. And but more power to all of us. And I thank the Creator for being here with us today. And you all get home safely. And if you're already home, say greetings to your families and to your communities. And I thank you all. That's it.